Welcome, everyone. It's great to have you all here at this FOREP Council's webinar, SMEs and Patent Holdouts, How European SMEs Fight Back. My name is Claudia Tapia. I am the president of FOREP Council, and I will be your host today. As you might know, FOREP Council is a not-for-profit research council focused on the link between intellectual property and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you can find plenty of free material, for example, studies, summaries of papers, guidelines, and recordings of our webinars. We also produce easy-to-digest content at 4SME Corner, specially tailored for non-IP experts, SMEs, and startups. We have just launched a new area on our website called IoT and Cellular Standards Made Simple, where you can learn about standards, their benefits, and their impact in the Internet of Things across different sectors. Check it out to learn more. You can also follow us on X, LinkedIn, YouTube, and Instagram. Our handle is @4IPCouncil. There you can find out about IP news, resources, interviews, and future webinars. Today, it is my pleasure to introduce our speakers, Jari Vepsäläinen and Timothée Le Quesne. Jari is chairman of Fintrade-Mercer Group. He is also a China-trained attorney and has been actively involved as a strategic investment advisor and corporate lawyer at the People's Republic of China for more than 36 years. And Timothée is co-founder and CEO of energysquare, a French company developing new wireless charging standards for electronic devices. We recently had the pleasure to interview Timothée in our podcast, IP Stories. I invite you all to find it out in our website under podcast and learn more about him as also his adventure as an entrepreneur. A final remark for the audience: please do not hesitate to use the Q&A tool to submit your live questions. You can find it in the lower part of the screen. You can raise your questions at any time during the webinar, and the questions will be addressed following the presentations. And without further delay, Jari, the floor is yours. Farid, you need to...
Right.
There we go.
Yep. All right, ladies and gentlemen, thank you so much for joining this patent holdout seminars, which is actually very important current topic. We are presenting some case here at the end, which is probably 2 or 3 months old. So you will hear some good solution what happened in this kind of patent holdout. So patent holdouts are situations where the patent holder has made contracts with the clients, where then the patentee for some reason doesn't want to pay or doesn't pay. So that is the patent holdout term. But before we go to this, the patent holdout itself, I would like to little bit explain you the China IPR legal regime. Just to give you background information and understand what we are talking about a little bit later. So this, in principle, the China legal regime is similar than it's in Europe. We have patents, software, copyright, trademarks. And here you see the lifespan. It's very similar to European standards. The different offices are in charge of different IPRs and applications. Now, invention patents are very well known in especially Europe, but these utility models are something which is new for quite many European companies, and we will later on discuss also this at this part, how to protect your better, not only with invention patents in China, but with utility models, designs, and especially software. China has been trying to make her legal regime better all the time. And a lot of European pressure has been also given to China, and China is all the time trying to make the legal regime better and better, suitable to us, in order to invite foreign companies to work in China, invest and do business with Chinese enterprises. However, there are still a few things to think, which is not the same like in Europe, especially the utility models, which are very fast approved in China, typically in 6 to 9 months, and there is no discovery. So you can register your utility model very, very fast in China, and it's 10 years. It's almost as strong protection like innovation patents. This we often talk to the European patent agencies, and they start to learn on this issue. Another interesting thing, that you can file your utility model same time like filing the innovation, in order to protect your innovation patents. Many of the companies are already starting to do this. So it's important for you to think about the Chinese way, not only think that things work in China as they work in Europe. So simultaneous filing is important. There's a lot of material in my presentation. It would take maybe 1 or 2 days to go through. I have 15 minutes, but we have prepared for you, so you can study later on and get some comments and get some advice how to do and what to do. Another important thing is China software copyright, because this doesn't exist in Europe. In the United States we have it, but not in Europe. So you are able, or actually you must register your software in China in order to protect your different software applications, which all the companies more or less have some software in their linked with their devices, which is important to have that registration in China. So now this copyright is 50 years, and it's first to file principle, like in everywhere in China. Whoever registered first owns it. In Europe, it's Berne Convention that who historically have developed or used is the owner, but China, whoever registered first is the owner. You have to remember first to file principle. All right, so these legal lawsuits, you need evidence, and you will get the very good documents after you have registered just software copyright. So China is member of all those important conventions, and there's of course information a lot of available for this intellectual property rights from them, and China is also trying to follow all those European rules and regulations what we have been used to it. All right, but coming now back to the patent holdouts, which is today's topic. So the patent holdouts are very, very important issues between European Union and China at the moment, as you will see from the case, which I will present a little bit later. China has been placed as the priority watch list, so that there's a lot of concerns that China will protect European companies and their IPs in China. So this is something what the for European Council, it's very strong and doing really good work. So that's patent hold-ups are different situations where patent owner sues a company and try to get their payments. These patent hold-ups are situations where typically there are a number of patents and patents families involved. They can be called also like standard essential patents, just like in a lot of in telecom and variety of in industries. So the why these kind of things may happen? First of all, some high-tech companies might license patents, know-how, technologies, but just don't want to pay. And that is the underlying cause for this patent holdouts. Or there's another thing that the patentees think that it's too expensive to pay agreed fees, whatever they are, 5 to 6% or whatever, and they refuse to pay, but they still are using those in their own products and sell them globally, which of course cause a lot of legal problems in the countries where they are marketing and presenting those products. So typically these kind of things happen when contracts are made and they have different delay tactics in order to try to negotiate better conditions for their payments. Okay, so that is kind of introduction. So what are the challenges for European SMEs? First of all, you know, these are very, very difficult matters to handle. And European SMEs are rather small compared to companies like Nokia or Ericsson or somebody else who are able to have a lot of legal expertise and power to negotiate with the patent holders. So one of the big problem here is this cost of litigations. They are very, very expensive, which is difficult for SMEs to enter. So you have to, you know, think about how to come in the solution that no need to have so much litigations with your clients, which you have already agreed and made agreements. So what are the strategies which you should be using? First of all, industrial partnerships. You could work with different companies, make a pool, patent pools, and work together. And that is very, very important. Second strategy is defensive patenting. As I talked a little bit earlier, you can patent other things, utility models, copyrights, everything which surrounds your patents, and joining different patent protection pools as well. Of course, legal matters, as I'm a lawyer, I know this very well, and that's from our point of view, it would be the last option. So you should have some other ways to solve the problem with your client, with whom you have already signed the contract, not that you know, you start to talk lawyers and they have their own lawyers. It's sometimes time consuming and really expensive. So there are also new ways now with China has this patent highways, which are country to country agreements. So you should check whether your own country has such agreement with China, like the Danish Denmark has done with China, which make all this faster and cost saving, and you have a probably much higher success rates to have a good solution for the dispute. So now, you know, if you use these highways, there are some country-to-country agreements which you should follow, and they are, as far as I understand, the Chinese side is also honoring very much all these agreements. All right, so now the case, you know, which is very, very important for you to know. I'm sure some of you know this. Oppo is a Chinese mobile phone maker, and Nokia Finland. They have been working together quite a long time, where Nokia has licensed the essential patents to Oppo, and Oppo started to market their phones around the world, but they failed to pay the monies to Nokia. So Nokia took them in a court in Europe, which they typically won, which resulted that Oppo had to leave European market. okay, that there are 19 courts, including, different countries, which means that it's very, very expensive endeavor. Once I was actually the vice chairman of European Chamber of Commerce in Hong Kong. We always talk to at least the Western companies that please agree between yourself of cross-licensing your own patent portfolios instead of talking to the lawyers. But you can see 19 court cases around the world. So as I told, in Europe, Nokia won, but they lost then in some other countries. But the most interesting thing here that they had the court case in China, and China typically is allowed now for the courts, normal courts, to negotiate, or let's say that the discount the contracts which the parties have been made in order to lower the payments due to the foreign parties, which is a little bit strange from legal point of view. Pacta sunt servanda is the keep your contracts. But anyway, so Nokia lost this at the first instance. It was in December, if I'm not wrong, 17th. But finally, they made cross-license agreement, which is it was a very good solution, I guess for both parties. So Nokia could get the catch-up payments. What they were asking, as well as they were able to agree how to go ahead in the future. It's a good example that settlement is better than court cases. So cross-license agreement exists, but there's not too much public information at the moment available on the contracts yet. Okay, just a short summary before Timothée starts to explain his situation. So first of all, so register. You must register everything you can. It's very, very important. And really, really important in China and everywhere else in China, know your partner. You should really, be like getting married with them and, work together. So it's very, very important. And one thing which Timothée will probably also explain is this freedom of law principle. You can use your own country or any other law, as well as arbitration in any other country which you might like. Typically, the Chinese parties say to you that you had to use Chinese law and courts in China, but that's not the case. It's a freedom of law principle. And of course, how you can stay ahead in competition all the time, continuously do R&D and register them. Any disagreement, aim for settlement. Don't go to the court. It's expensive and it's very difficult to predict the outcome. And anyway, so work with IPR experts, especially those who are, in Asia or China, because often what we have seen that European companies, they don't understand how China works. All right, but that's more or less from my part in the beginning. So maybe Timothée can continue with his presentation.
Thanks a lot, Jari. Hello, good morning, everyone. So I'm Timothée. I'm a co-founder and CEO at energysquare, and I'm here today to talk to you about our vision of IP as an SME, about our licensing experience in China, and how we try to avoid patents holdout. So we are a French company based in Paris. We've been created in 2015, and we are developing new cableless charging technologies. And our goal is to get rid of as many cables as possible in the workspace and in other market verticals, such as consumer device or professional device. And we developed a new technology called Power by Contact, allowing, unlike inductive charging technologies, to charge multiple devices simultaneously at the same speed and efficiency as with a cable, and with full freedom of placement and cost effectiveness also for the device manufacturers. So as our goal as the company is to build a technology standard and to be embedded in as many devices as possible, our commercial activities are based on a quite classic licensing business model. So we first provide proof of concepts to our clients. Then we do a technology transfer, and we typically charge technology access fees and NREs. And then we let our licensees exploit our IP, and we take royalties on that based on the number of devices produced. The first very important point that I wanted to highlight today is that a lot of SMEs consider IP only as a protection tool. So either a defensive tool, allowing you some freedom to operate with your technology, or an offensive tool, so being able to take action against a third-party infringer. But it's also very important to consider IP as a business tool, as a leverage for your business that can actually allow you to create new business models from scratch and become, at the end, a source of revenue. And at energysquare, we have been able to change from our initial B2C product selling business models that we had between 2015 and 2018 to a B2B licensing business model, thanks to our very early investments in IP, and also thanks to the diversity of our IP assets. And having this strong and diversified IP also allowed us to have more bargaining power, I would say, when we negotiate licensing agreements. So I told about IP as a business tool, a tool to increase your revenue. Then we think it's also very important to see IP as an analytic tool. Especially if you intend to expand to new countries such as China. So some IP analysis tool will allow you to have a very good understanding of your competitive environment in different countries, of your technology advantage, and of your barriers to entry. And two of these tools are quite simple to use and very affordable. And we use it in different contexts at energysquare. The first one is a patent mapping. So patent mapping will give you a kind of elevation map of where competing IP stands compared to your IP based on industry sector, for example, or based on country. And also patent database where you can look for similar IP in other countries can be very efficient. So now, what is our licensing experience in China? So overall, we negotiated 3 licensing agreements with Chinese and Taiwanese companies of different sizes. All of them were ODM companies, so companies offering manufacturing services for device brands. We had a very different negotiation experience with each of these companies. One signed very rapidly our agreement in a few days with few requests. The second one negotiated for a few weeks, mainly the royalty price and the payment conditions. And with the last one, negotiations took more than a year, so it was very long, with almost every article in the agreement being discussed. And I was very surprised that cost of the technology and royalties were often not the main issue in those negotiations. We came to an agreement quite easily on those topics, but the main friction points were linked mainly to liability and warranty clauses. So what happens if the device embedding our technology fails for technical reasons? And what happens if our IP embedded in the device infringes a third-party IP, or if a third-party device infringes our client's product IP? And also a rising IP was always a difficult topic to discuss. So who is the owner of the IP arising from the project? I think there are 3 things that helped us in this liability and warranty negotiation. The first thing is that we defined a very precise test plan with the licenses in case of product failure to define if the issue was their responsibility or our responsibility. And at the end, who should take action depending on the results of this test plan and who should pay for it. And on this point, I think the more precise and factual you are, the more reassuring it is for everyone. The second point is that we defined very clearly what happens if our technology embedded in our licenses device infringes third-party products. So who leads the negotiation? Who pays for it? What is the maximum amount of liability associated to IP issues, etc. And same thing if a third-party product infringes the IP embedded in our licensee product. And the last point that is also very important is that the devices embedding our technology cannot work without our firmware. And we have a very strong control on it, on the firmware, and our clients can only access it through an interface that we provide. So if we do not come to an agreement with a company regarding, for example, royalty payment, they have no way to embed our technology, because even if they try to copy our hardware, they cannot do so for our firmware. And I think it's also very important this is a very important point to try to avoid patent holdouts. If you have a technical way to stop the integration of your technology in a product, then you have a very good method to avoid patent holdouts. A few other important things when exporting your IP to a Chinese market. So in this negotiation that we had, I think that the fact we had many IP rights to license and not only patents was quite reassuring for our licensees. And to be honest, I think that they did not even look at the precise content of our patents, but the fact that we had a quite dense portfolio plus other IP rights made the process easier. So you should invest early in IP and diversify your IP portfolio. So have a clear overview on your trade secrets, trademarks, know-how, software, firmware, electronic designs if you have patents and other IP rights, and provide a dense and a complete list to your licensees. We sometimes had also to consult local law advisor firms to smooth the process, mainly because of, I think, the language and business culture barrier, and to read between the lines. So don't hesitate to get support from local advisors, as Jari mentioned. For some agreements, we managed to choose our home law as the ruling law of the agreement. And this is also something you should for sure negotiate. And as I said before, try to have a technical way to control the number of units produced and to stop production in case of patent holdouts. So my last slide, here we go. So now, what are our next steps to avoid patent holdouts? I think many companies in our industry are willing to create a consortium around contact-based charging technology, such as the one we are developing, to define specifications that will guarantee interoperability between the chargers and their devices. And this is also what we want to do. And the good points for an SME holding IP in such a consortium is that it will bring you some interoperability. It will increase your credibility as a company, and it will define very clear IP rules on which all the members of the consortium will have to agree if they want to implement the technology. And you will share also some IP risks with other companies in case, for example, you build a patent pool, what Jari also mentioned. The drawbacks is that you can lose part of the control over a technology, and maybe you will have more competition in selling some services around the technology. But we believe that it could still be a good way to avoid patent holdout, especially if there is a trusted and independent organization working with the consortium and controlling and allocating the firmware keys in case the innovation embeds some firmware, and that can stop allocating it to members that are not respecting the consortium IP rules. So yes, these were the main points that I wanted to highlight today regarding our licensing experience in China. So thanks a lot for your attention, and happy to answer to your questions if you have any.
Thank you so much, Timothée and Jari, for your presentations. Very enlightening. And Let's start with a few questions I have here. In the meantime, we can collect those from the audience. Remember, in the Q&A tool down. So, Jari, you mentioned companies holding out, owners of intellectual property rights, delaying payments, which put companies, in particular small and medium enterprises, in a very, very difficult situation. And litigation can be, as you explained, very costly. If I heard correctly, almost $1 million average. And this can be really, really burdensome for SMEs. Can you provide an example of patent holdout situation?
Well, there are quite a lot of these, situations, as we so Timothy also explained. Well, the big cases like Nokia and Oppo, now it's good how it was sold finally. I think everybody's happy. Also, Oppo is happy now; they can sell to Europe, and they can maybe they are better than some other competitors. But for smaller companies, this is a real issue. So how do you make sure that you are getting paid, and you are getting paid what you have agreed? So you had to know your partner, and of course you had to have always something else to provide to them. So the continue your own R&D, that you have huge 2.0, 3.0, whatever. Keep your that important to them. Another thing which is also important here is that I understood that, like, Timothy used the home laws, French laws, and arbitration, at least some cases, which is important. Then it's very difficult and expensive for Asian companies come to Europe. They know it. So, but if you are using local laws and local court, normal court, they know people. So this is one, very strategic thing that, it's called, as we said, freedom of contract. So use that old, principle.
Very good. Timothée, how did your patent portfolio look like when you negotiated licensing agreements in China?
So when we started talking to Chinese and Taiwanese companies, we had about 6 patent families, which is not huge, but I think it was very good patents that kind of locked key parts of the technology. And also there were at different steps of filing in different countries. So some of them were already registered in China, and some others were not. But we also had a very structured IP portfolio in parallel of our patents. So in our licensing agreements, we license not only patents, but also some know-how, some trademarks, some firmware, some electronic layouts, etc. So the royalties are not based only on patents, but also on a lot of other IP assets that we provide.
Mm-hmm. And Jari, here is a question for you. What are some common challenges that SMEs face when dealing with patent holdout?
Well, I think the first of all, the most important is the costs. If you try to get into litigation, so you should negotiate. You should talk to them, agree. That's the most important. So that is a challenge, and it might be time consuming. But the best way is to try to settle it and offer something else. Like Timothy explained, they have quite a lot of things what they offered. So as long you are valuable to them, I think they will work with you. So that is important. Continue R&D and continue IPR and settle. Make agreement how to go forward.
Talking about agreements, Timothée, I heard 3 agreements signed in China. Congratulations. Have you ever faced issues with IP in China? And if so, could you share?
We did not experience patent holdouts yet, because I think we had this good way to stop the production, because we control the firmware part of our technology. Then we always had discussions about how we count the number of devices embedding the technology. So I think you need also to find a technical way to know the exact number of devices embedding the technology, or to have some ways of controls. And then we had sometimes some issues with trademarks, with trademark squatting, but as in a lot of countries. And then it becomes long procedures to try to get back the trademark. So I think it should be something to invest in very early to have the trademark in the Chinese market.
Makes sense. And I see Jari nodding. Can you name, Jari, one strategy that small and medium enterprise can use to protect themselves from patent holdout?
Well, of course, the most important, as Timothée explained, is register. And that is, also including trademarks. You have to remember one thing, that, Hong Kong is a different jurisdiction. So you have to register trademarks and what patents, whatever you have, separately in Hong Kong. Because now, you see, according to the European Commission reports, you see, Hong Kong is one of the biggest, counterfeit, trading center. So they are selling products out from China or via Hong Kong, but Hong Kong jurisdiction, if you are not registered in Hong Kong, the customs or police or whoever cannot do anything. So you have to register your trademarks and everything also in Hong Kong. If somebody is taking the products out from China and selling to somewhere else, Hong Kong customs can stop it, but it had to be registered in Hong Kong. So this is very important to understand.
Thank you. And I have here one question, it seems to be for you too, Jari. If you go foreign shopping abroad, how do you enforce a verdict in China?
Excellent. A very good question. Now in arbitration, so typically, of course, we are from Hong Kong. We always try to get the or we propose that we have arbitration in Hong Kong, which is old-fashioned British system. Now the arbitration, you see, if you are foreign shopping, enforce the arbitration awards in China. It's not, of course, easy. So you have to get to the intermediate courts in that province where it's located. So it's another thing, you see, where what is once you win, and how to enforce that in China. The one thing is that, you see, if the Chinese company have already big branch in Hong Kong, you can make a contract with the Hong Kong company, Hong Kong law, and arbitration in Hong Kong. Enforcement in Hong Kong, it's easy. But in China, as I said, it goes to the intermediate court. So, but forum shopping is important in this respect. But if you win, you still have a little difficulties to get it enforced.
Indeed. There's also a question, but this time for you, Timothée. Which patent databases are you using, and who is performing the respective searches?
So we did this patent mapping study with ENP, which is a French Institute for Intellectual Property, but there are a lot of tools existing. And the patent mapping tool gives you a first database. So you have this map, but you also have the list of patents behind the map. And then for the patent database, we use several ones. The one from the European Patent Office, for example, that is very powerful. And we try to compare both, so to compare what we had when we did this patent mapping and the results we have when we do research from a live database.
Thank you. There's also a question here. I'm not sure for whom, so I'm gonna just share it and you choose. So here is someone thinking about the future of small and medium enterprises that have specialized in an IT technology that has been prohibited. And an example is bringing traditional medical services. What do you think about the future of these SMEs? What can they do?
I think, Timothée, you know this area better than me.
I don't know how to answer to this question.
That's okay. I mean,
of course, they are, if from legal point of view, there are some, prohibited areas at the moment in China, where they don't like foreign companies to enter. And there is also this data transfer security law in China, which restricts information from China to come out to foreign countries, which is giving a lot of problems, because if you deliver something, you need information online, but it's forbidden. These are things that, you know, also Europe is talking to China, that we need access to those equipments or machines which we have delivered from Europe to know that they are working well and properly. So the data security law is giving a lot of, let's say, headaches at the moment.
Mm-hmm. Yes, we hear a lot of challenges. It sounds like a little more positive way to say it, but indeed. I have here also a question, because we have heard before also for Jari about costs. Timothée, how did you finance your IP?
Yeah, so this is a good question, and I think the main question for a lot of SMEs and startups. I think the good point is that most of IP tools are not expensive at all. It just requires some time to invest. But for example, NDA can be quite powerful, and it's free. Protecting your know-how is just a question of time. The firmware also. Trademarks are not so expensive. So the only expensive thing is patents, especially if you want to have one patent in 4 or 5 different countries. So you have to look at national tools that might, or programs that might help you financing your IP. For example, at energysquare, we participated in a French program called Patent Factory, and they helped us financing part of our patent portfolio. The program is over now. But you might find some tools in your countries, public or private, to finance your IP.
Mm-hmm.
If I can continue,
yes.
what I explained earlier, the utility models are important in China. It's no discovery. You can get it approved as it is if there's not exactly the same on the market. It takes 6 to 9 months and it's relatively cheap, 10 years. This is a way which, you know, we don't have this in Europe. It's a petty patent in United States, but in China it's almost as strong as innovation patent, but it's easy. So that is what, you know, the SMEs should think about it. It's a technical solution, you know, to the issue.
Maybe because I'm not sure if everybody here understands the differences. In which scenarios will you file one and when you will file the other one?
You see, if I may continue this, so the innovation patents are very well known in Europe. They are innovations which are filed in Europe, and then, you know, within the certain time they had to, you know, be outside. But these utility models are not so very well known by European professionals, but that is easy. It takes easily, you know, 3 to 5 years to file an innovation patent, and then you extend. It's expensive, but utility models in China it's let's say 6 to 9 months, documentation maybe 20 pages, and you get it. Then you are protected. It's almost as strong as patent. There are a lot of cases where Chinese have won European innovation patent cases because typically those innovations in Europe, they file very generic terms. You see, they are not explaining all the details, but then the Chinese competitors file utility models. They exactly explain what it is, and if there's any, you know, dispute or court, Europeans lose.
I see Timothée also nodding.
Yes, and I can confirm that invention patents, the kind of which we have in Europe, take a lot of time to file in China. And for us, sometimes the patent, it's finally registered 4 or 5 years after it was primarily registered in France or in Europe. So you should definitely look for other ways, as Jari mentioned, to have shorter time frames for registration.
Jari, you were talking before about challenges. Are you aware of any government initiatives or policies in Europe that support SMEs in navigating patent-related challenges?
Well, I think this, you see, there are a lot of policies in Europe to assist. You see, the SMA, you know, help desk is one. and they are very well known in China, as well as, if you have a problem, the European Commissions or European governments, they will help you. So I mean that if you have a problem, don't be alone. Don't be too shy to ask support from EU, officials. They will help you. And it's always good to, if you have some, cases, it's better to report to the government so they can then take it on the table, you see, to the opposite side, especially in China. So they can try to solve it together.
Indeed. I have here a question. I'm not sure if you have been following this discussion. This is more related to the SEP regulation, which has been proposed in the European Commission and now is subject to vote to the Parliament in a few days. And someone is asking whether they think it will help small and medium enterprises or not. Have any of you been following the discussion?
Maybe you are the best to answer, right, Claudia?
Well, I can tell the idea was to get more transparency and help small and medium enterprises. In the meantime, more and more concerns have been raised regarding implementation and the additional costs that will come, and whether it would really help SMEs, or rather be more burdensome than originally. So I think we have a couple of papers on this in for IP Council, in case that someone wants to be following this discussion. And here we have another question, which is how do fast-tracked Chinese patent applications impact patent holdouts, if at all?
Well, there's this patent, highway exists now. It's they are mainly made by country to country, like Denmark has one. So you should check whether your country has such patent, highway prosecution highway, which typically, like Timothée said, maybe 3 to 5 years. So this can be 1 to 2 years. So there's this kind of method now. It's country by country. So it depends from which country you originate. But I can understand that European Union is planning to unite many of these country-to-country agreements with China. So it would be better that this kind of agreement will be made on the European Commission level or whoever, not country by country. But at the moment, it is country by country.
Mm-hmm. Timothée, how did you get to meet your Chinese customers?
It was mainly during trade shows. So in our industry, there is a trade show called Computex, holding each year in Taiwan, and it's focused on the laptop industry. So there are a lot of potential clients there. So I think you should organize 1 week or 2 weeks of meetings before or after the trade show. Go to the trade shows and meet them physically. It's very important, going in their offices. So this is how we met them. And we also participated in some programs by Business Friends, so a French agency to promote French companies abroad. And they organized different meetings with us with local antennas that had a good knowledge of our clients and potential clients.
Mm-hmm. We talked, Jari was mentioning before, register. But are there any other ways that you can protect your IP other than registering your intellectual property rights?
That is very good point, Claudia. And this, you see, you have to make all this in your contract. You have to make they are not able to use, they are forbidden to do this, you see, and that is then the contractual dispute. So it's a different, jurisdiction. So it can be, and if you have a freedom of law, if you have French law or Swedish law or British law, you can sue them in your own country and arbitration. Most likely, if the case is clear, they will lose it. So that is the thing that you can put it on you have to put them in a contracts as well, that you can have a contractual dispute with them, not only the IPR dispute. Mm-hmm. And different, penalties you see in the, 500,000 or 1 million, whatever. So you understand my point there.
And I think that secret can also be a very powerful tool, and especially regarding software and firmware finding a way to encrypt it and so that they don't have access to all the source code. For certain technologies, it can be very powerful as well, in parallel of registration.
I see. So let's imagine now the SMEs wants to protect their intellectual property. What are the challenges that usually SMEs face?
So maybe Timothy, you know this really well.
Yeah, I think time and costs are the main challenges because it takes a bit of time to organize a clear IP strategy, to make the list of all the know-how or frameworks that you can have, and that is the core of your IP. And then cost, we already talked about it, the cost of patents can be quite expensive. So you have to find some innovative way to finance it, or to try to reduce the registration costs, as Jari mentions, with other tools.
Timothée, you were talking about IP strategy, and I was wondering, what can you share for those who are listening today about your IP strategy?
Yes, so we spent a few months in 2020 defining our IP strategy. I think the main important point is to have everyone in the company involved, so that everyone knows what a patent is, what IP is, what kind of different protection tools you can use, and to understand as a company culture that IP can be a very strong business leverage. So this was the main point of defining the IP strategy, so that everyone has the same vision of IP in the company. And for example, we had this a big Excel sheet with which listed all our IP, and we know very precisely, everyone knows when they can share it or not, under which agreement with which company. And this is quite powerful to avoid to share something that you don't want to share, or that will bring damage to the company.
As we are approaching to the end, I'd like to invite you to contribute a last thought, a recommendation in 1 minute or less that addresses the question, how should European SMEs fight back?
Well, if I start first, so I think you have to continue your R&D research all the time. Let's say like in mobile phones, what we believe that, you know, Ericsson and Nokia, they are really heading 5G, 6G. And for European point of view, it's very important that, you know, we are getting, you know, fair payments for royalties in order that we can keep then the 7G, 8G, or whatever 10G ahead of other countries. So it's very, very important to continue R&D and try to get paid. You know, okay, now you have patented your license, it maybe pays you and profit for what you have done already, but you need money to develop the next and next and next generation, like you know, to be ahead of the game all the time.
And I would say, so how should SMEs fight back? I think first step is to invest in R&D, as Jari said, and in IP. Then structure your IP, so know exactly what you have in your company, what is valuable, and what can be sold to licensee. Then prepare, so know, for example, how your IP compares to similar IP of a Chinese company if you are planning to license in China. Try to find technical ways to avoid patent holdouts if it's possible in your case. And of course, be helped by local advisors if you face any issue.
What about defensive patenting?
This is very important topic. So like you see, you can use these utility models. If you have any technical, let's say like Timothy has a technical or some design in his products, so you can you know, use this utility models that nobody can make a similar or looks the same product. You understand? So it's better to use this kind of defenses. So in many issues, this you know, utility models in China are So like innovation patents might take 3 to 5 years. You can first register, utility models surrounding it. And then once you have innovation patents, they exist there, or you can cancel them. But it's like the first, round of defense, 6 to 9 months.
Very good. On that note, we conclude this virtual patent event. Thank you very much, Jari and Timothée, for sharing your knowledge and expertise. And thank you also, all of you, for attending this webinar. A recording of this presentation will be made available on for IP Council webinar website tomorrow. And please don't forget to register to our upcoming live webinar taking place on March 13th at 4 p.m. CET about fashion, IP, and sustainability. And you can find out more using the QR code or on our website under webinars. And finally, I would like to recommend you that tomorrow you will, because you're going to receive an email inviting you to complete a 1-minute survey about this webinar, and we will be very, very grateful for your feedback. So thanks everyone, and goodbye.
Thank you.
Thank you very much.